Good morning, friends. I will talk about Resjudicata. In a notable judgment explaining the principles of Resjudicata, the Honorable Supreme Court has held that an order closing the proceedings in a case cannot be construed as a final decision on merits so as to bar a subsequent suit. Accordingly, the court set aside a judgment and decree of the Delhi High Court, which rejected the plaint of an eviction petition for being in violation of principles of the res judicata. The divisional bench of Justice Sudhanshu Dulia and Justice J.B. Pardiwala observed that the order passed by the rent controller on 27th of January 1998 did not purport to be one of dismissal for default or on merit, and it cannot be taken to mean other than but is purported to be. The order did not purport to be a final disposal of the suit, it merely stopped the proceedings. It did nothing more. This is not final decision of the suit within the meaning of Order 9, Rule 8 and Order 17, Rule 3, respectively, of the CPC. Now, the court further summarized the principle of res judicata. The court summarized the principle of res judicata as first one is to reject a plaint on the ground that the suit is barred by any law. Only the averments in the plaint will have to be referred to. The defense made by the defendant in a suit must not be considered while deciding the merits of the application. To determine whether a suit is barred by res judicata, it is necessary that the previous suit is decided, the issues in the subsequent suit were directly and substantially in issue in the former suit. The former suit was between the same parties or parties through whom they claim, litigating under the same title. And these issues were adjudicated and finally decided by a court competent to try the subsequent suit. Since an adjudication of the plea of res judicata requires consideration of the pleading issues and decision in the previous suit, such a plea will be beyond the scope of Order 7, Rule 11, Subclause D, where only the statement in the plaint will have to be proved. Now, these were the observation. The facts of the case are the father of the appellants, that is a landlord, filed an eviction petition on May 21st, 1996, under Section 14(1)(a) of the Delhi Control Act 1958 against the respondents, that is tenants, alleging that the area of rent was not clear. In the said eviction petition, the respondents denied the relationship of landlord and tenant. However, plaintiffs' appellants failed to appear before the rent controller for the purpose of establishing the relationship of landlord and tenant between the parties. The plaintiffs were granted numerous opportunities to adduce evidence to establish the relationship of landlord and tenant. Last such opportunity was given on November 1st, 1997. The rent controller passed an order dated January 27th of 1998 stating as follows. The PE is closed. Since the relationship of landlord tenant itself is under dispute and the petitioner has failed to adduce any evidence to establish this fact, I am of the opinion that there is no point in fixing the case further for RE. The petition is thus dismissed as the petitioner has failed to establish his case. File we consigned. This was the order. During the lifetime of the original plaintiff, no appeal or fresh eviction petition was filed. After the demise of original plaintiff, the appellants, claiming a successor in interest, filed another eviction petition in the year 2001, engaged the respondents under Section 14(1)(a) of the Act of 1958, claiming arrears of rent from March 1st, 1993 till the date of issuance of the notice, that is till May 18, 2001. The respondents filed the written statement and an application under the provision of the Order 7, Rule 11 of the CPC, stating that the said eviction petition of 2001 was barred by the principle of res judicata and the plan shall be rejected accordingly. However, the additional rent controller declined to reject the plaint wide order dated July 23rd, 2002, on the ground that the second eviction petition filed in was based on a fresh notice dated May 18, 2001, on separate cause of action, and that there was no finding on merits as regards the relationship of landlord and tenant between the parties in the order dated January 27, 1998. The respondent tenants approached the Delhi High Court in a civil revision petition challenging the impugned order dated July 23rd, 2022, which was allowed, and plaint of eviction petition of 2001 was rejected by the High Court on the ground that the same was hit by the principles of res judicata. So the appellant approached the Supreme Court challenging the impugned order judgment of the Delhi High Court. So the issue which crop up from the above mentioned facts were whether the finding recorded by the rent controller while dismissing the eviction petition of 1996, that the eviction petition deserved to be dismissed as the plaintiff Sambe Singh had failed to establish the relationship of landlord and tenant between the parties, could be said to be on merit so as to render the second eviction petition of 2001 not maintainable on the principle of res judicata. In this case, to decide this issue, the Supreme Court noted the general principle of res judicata under Section 11 of the CPC contained rules of conclusiveness of judgment. What for res judicata to apply, the matter directly and substantially in issue in the subsequent suit must be same matter which was directly and substantially in issue in the former suit. The suit should have been decided on merit and decision should have attained finality. So the Supreme Court noted that the exact word used by the rent controller in the order dated 27th January 1998 are the PED does closed. In the second part of the order, the rent controller proceeded to observe that since the relationship of landlord and tenant is under dispute and the plaintiff has failed to produce any evidence to establish such a relationship, he did not find any good reason to fix the case further for recording of evidence. In such circumstances, he dismissed the eviction petition as the plaintiff could not be said to have failed to could be said to have failed to establish his case. In the last, he got that the file be consigned. The court averred that the above mentioned order do not mean dismissal either on merit or on default. The court further ruled the word which we have quoted above certainly do not mean dismissal either on merit or on default. It was argued before us that the order should only be taken to mean what an order under Order 17 can possibly be, and nothing else. We are not impressed by such submission. Thus, the court allowed the appeal and set aside the impugned judgment and decree passed by the Delhi High Court. However, the court clarified that we have not expressed any opinion on rival contentions regarding the applicability or otherwise of principles of res judicata or for that matter any other contentious issue in the pending suit. Nothing stated in the judgment will prevent the concerned defendants from requesting the court to decide such an issue as a preliminary issue. Such an application would obviously be decided on its merits, about which also we express no opinion. The suit is revived. So, after going through this, the Honorable Supreme Court said this is not the case of res judicata. They again order the trial court to reconsider the whole issue and try it afresh. This is all about this. And if you want to know the case title, this is Prem Kishore and others versus Brahm Prakash and others. And Korma, I have already mentioned by Justice Shidanshu Dulia and Justice J.B. Pardiwala. And the from where I am taking it, citation 2023 Live Law SC 266. So in this case, the Code of Civil Procedure 1908, Section 11, res judicata was discussed, and this is the main contention on which the whole judgment depends. And further, the Order 17, Rule 3 was also discussed of the CPC,